handcuffs. Yeah. I'm saying that. Okay. So put your hand in the back. Let me say your arm and jump out of my stop. Required. Turn on, put your hands on top. For what? You're under arrest now. For what? You're under arrest now. Yes. Turn on, put your hands on top. Yes. Turn on, put your hands on top. Arrest or obstruction. You just rolled down through here, which is a violation of the law, and you broke your heart down your traffic stop. Can't do that. You're not listening to me. So there'll be more people coming and you'll be going to handcuffs. You will. Huh? What was I doing that? What was I doing? This one? Oh, I take it. I would kick your ass, bro. You think so? Well. I'm supposed to take my firearm. Let me in. Now we're down out, go back to it. So we can go that route. I'll shoot you. You pull it back, you pull that pistol out, I'm gonna shoot you. You will not pull that down. You will not pull it down. You will not do that. You understand? You attack me. I will defend myself. If you don't stand, then you'll contact me until you're back. You are under arrest at this point. You cannot leave.
All right, today's case is everything. Flashing lights, a drawn gun, a suspect who refuses to listen, and one phrase that sends the whole courtroom into stunned silence. Because when a guy tells an officer, "I'm going to cook you," trust me, the judge does not take that well. So here's what we're walking into. A routine traffic stop turns into a high-intensity standoff when officers pull over Thomas Styron, who's driving with no plate, not stopping right away, and eventually steps out saying he's armed.
67. He's a firearm. And there's out of his vehicle and feeling the power commands. Stop raging. Stop going. Yeah, obstructing, get something in here. You're power away, you're down versus bit. I can stop you, I can talk to you. You and down the left. Yes, you will. You can.
For the record, sorry to interrupt here. And I'm going by the time marker on the Axon body camera. Defense started playing at 12:05 and 18 seconds, and we're now stopped at 12:08 and 36 seconds.
Thank you. So, Officer Hoke, you had stated that you came out in the low and ready, correct? I'm sorry, I didn't hear.
Yes.
Yes, I apologize. And Officer Hoke, you had stated that the pistol was not pointed at Mr. Styron before he informed you that he was armed. Is that correct?
Ready. It's in his direction, but I hadn't leveled it completely at him yet. You see when I leveled it at him when I brought it completely up. The little ready, it's resting right here. It's resting right here. So it's not directly pointed at him, but it is pointing in his direction. There's a difference between low ready and pointing it directly at him.
So, Officer, do you believe that this was a de-escalation tactic?
And definitely not in the mood to be handcuffed today. The prosecution says this is a clear-cut case of fleeing, resisting, and threatening an officer with a concealed weapon. The defense? They say Styron was terrified, overwhelmed, and reacting to an officer who came out with a gun already drawn. And the judge? The bodycam playback. The hearing starts with the bodycam footage. Always a good sign that things are about to get spicy.
This is me telling him exactly what he needs to do. So yes, this is a de-escalation tactic.
So at any point, did Mr. Styron point a weapon at you?
No.
Okay. So at any point, did you actually see a firearm on Mr. Styron?
No, sir.
Okay. Officer, when you were giving these commands to Mr. Styron, your pistol was out the entire time, wasn't it?
Yes.
Okay. From the onset of the stop throughout the entire incident, your pistol was out, was it not?
I believe there was a market there where I either holstered or was almost holstering before I to make contact with him before he was armed. I can't remember if I went all the way to the holster down my side, get ready to go into the holster before I make contact to make a little arrest. When he said he was armed, I backed up and put one that directly at him.
Officer, isn't it possible that your pistol being out could have impacted his ability to follow these commands?
No.
I have no further questions, Your Honor.
Yes.
You indicated in one of your answers something about lights being on, and you use a siren because you want to give somebody every opportunity to stop.
Yes, they needed to pull over. Yeah.
Fair to say that that is what you did here. First, you attempted to use your lights. He didn't stop.
The prosecutor pauses to mark timestamps like she's narrating a National Geographic documentary, and immediately we learn one big thing: the officer's gun. Out from the start. Defense jumps on this instantly. You had your pistol out the whole time, right? You didn't even know if he had a gun yet, right? You never actually saw a weapon, right?
Yes. And then you turned to your sirens as well to try to get him to stop.
Yes.
You didn't want to have a situation where he claimed he didn't see your lights.
Right.
Thank you. Pointing the gun at him. You're a sergeant, correct?
Yes.
Fair to say you have extensive training and experience on police officer safety.
Yes.
You are not required to wait until a defendant has you at gunpoint before you draw your weapon, correct?
That's correct.
And you are not required to wait until a defendant has fired at you, risking your life, until you point your gun at him, correct?
Correct.
Thank you. I have no further questions.
Anything else?
Just one further, Your Honor. Regarding the cook you. Okay. Now, we hear Mr. Styron say, "I'm going to cook you," correct?
Yes, sir.
Okay. Does Mr. Styron go on further to say what "I'm going to cook you" means?
Yes, it did.
What did he say?
When I asked him to clarify about the statement while we were having dialogue, and he said that he cooked me like exactly religiously, something to do with suing me. It was no problem suing me.
Thank you. No further questions.
Okay.
Thank you.
Keep
Just to
going
be
back.
clear, we listened to the recording of that while we watched your body camera, right?
Yes.
To be fair, what he says is, "I'm going to cook your..."
Your weapon is pointed downward.
Yes.
Is that correct?
Yes, sir.
And there is a clear point on the video after he tells you or informs you that he's armed, that you then bring it basically to the ready.
Yes. Yes, sir.
All right. Thank you. Anything else from either side?
Nothing for the people. Thank you.
Nothing further from defense. Thank you.
Sergeant, thank you.
Yes, sir.
Your Honor, the people have no additional witnesses.
Any witnesses for the defense?
No witnesses from defense. Thank you kindly, Your Honor.
Motion.
Thank you, Your Honor. This time the people would motion to bind over on an amended information that added count 4 felonious assault, added count 5 felony firearm, added count 6 felony firearm. Thank you.
The officer answers yes, yes, no, yes, like he's pressing buttons on an elevator panel. Defense is basically building the argument that the officer escalated the situation before Styron even opened his mouth. But then we hit the phrase the prosecutor flips the script. "Officer, you heard him say, 'I'm going to cook you.'" And then the officer adds that when he asked Styron what that meant, Styron explained it. Never a good thing when the threat requires footnotes. He was scared. The gun was out. He couldn't function. This wasn't a threat, it was panic. But the judge raises an eyebrow so high it practically leaves orbit. That almost seems counterintuitive. You're saying he couldn't follow commands because there was a gun out.
Your Honor, defense would move to dismiss the felonious assault. There was no indication that a weapon was pointed at the officer at any time. There was no imminent threat of a weapon being pointed at the officer. Leave the requirements.
There was no imminent threat. Say that last part again.
There was no imminent threat of a weapon being pointed at the officer.
Okay, go ahead.
We would move that be dismissed, Your Honor, as to believe that with the weapon being, with the officer's pistol, I want to phrase it, with the officer's pistol being present from the beginning of the stop to the entire incident throughout, my client, Mr. Styron, wasn't able to function properly in obeying the lawful commands. He was placed in a state of fear.
So you're saying the sergeant's command to put your hands on the vehicle, he couldn't follow because the officer's weapon was drawn? That almost seems counterintuitive to me.
Your Honor, the situation was escalated to a point that it didn't need to be at, Judge. It was an unreasonable use of force at that point.
Okay. I'm going to vehemently disagree with you. And probably one of the reasons I'm not a police officer, because I don't know that I could have had the discipline that the sergeant did. But go ahead.
And with those two counts, Your Honor, the fleeing and the looting there was only 20 seconds of, let's see, at 23:50 in the video, the sirens go off. Excuse me, the lights turn on at 23:20, the sirens going off at 23:50. If he didn't see the lights for those 30 seconds, there's only 20 seconds of actual siren time. And I believe that is an adequate amount of time for someone to be pulling over, Judge. So if he stopped at that appropriate amount of time, 50 seconds total, Your Honor, would be a reasonable amount of time for someone to pull over. I don't believe there's enough to go on the fleeing and the looting. We would ask that that be dismissed. If those are dismissed, the felony firearms cannot follow. So for those reasons, we'd ask not to bind over. Thank you, Your Honor.
Thank you, Your Honor. So this is a situation where people don't understand that when the police stop you and the police are effectuating an arrest, it's not a mutual argument. You don't get to fight with the police. You don't get to pull your gun out. You are under arrest, and this sergeant is in control. And when Mr. Styron refused to turn over control to the sergeant, he committed felonies. So first, to say that 50 seconds is a reasonable amount of time, I mean, to pull over a vehicle, it takes seconds to pull over a vehicle. We can all, and Your Honor could take certainly judicial notice of your experience as a driver as well, that you can immediately pull over your vehicle, and that is not what happened here. However, if Mr. Styron had
pulled... What do you mean, that I've been pulled over?
No. Just that genuinely, yeah, you've probably pulled a vehicle over at some point somewhere, unrelated to the police. But Mr. Styron doesn't get out of his vehicle and say, "Oh my goodness, I'm so sorry, I didn't see your lights." He proceeds to argue with the police officer as if he has any leverage in this equal argument, which it's not. It's an arrest. Officer caused fear in Mr. Styron. Frankly, I hope that he did, because I hope that Mr. Styron realized how close he was to being shot given his actions. But
she basically says, look, if anything, that gun should have encouraged him to follow instructions. Defense tries their next angle. It was only 20 seconds of sirens. Judge. He didn't realize. Prosecution, with the confidence of someone holding an Uno reverse card, replies, you can pull over immediately. Also, he didn't get out apologizing, he got out arguing. The judge nods along like she's listening to a podcast she already agrees with. The felonious assault argument, he never pointed a gun. You can't assault someone with a gun that's never drawn. Judge, interesting, but wrong. She explains that an assault can be verbal if the threat is credible, the person has the ability to carry it out, and the victim reasonably believes harm is coming.
What Mr. Styron was able to do was not freeze up in fear, not cry, not be so scared of the officer, but instead say, I'm going to cook your ass, bro. Yell at the officer about how he is at his house. Yell at the officer about how he's not going to be put in cuffs. That's not somebody who's just frozen in fear. That's somebody that doesn't understand what the law is and doesn't understand that this sergeant is the person that was actually in control. Thank you, Your Honor.
Thank you. Judge Kelly, anything else?
Nothing further, Your Honor. I would emphasize on the felonious assault, though, there was no weapon pointed at the officer at this time. The officer was in control of the situation, Your Honor.
But hold it. To have your argument is that the weapon would have had to have been drawn or displayed to have the felonious assault?
Your Honor, the officer was in control of the situation. He had his weapon drawn, and Mr. Styron he's a CPL holder in this situation, Judge.
All right, that's fine.
He told him he had the gun on him.
Arguably, yes.
But it's at the very least, Judge, the felonious assault, I would be pushing a little harder on that one because the weapon was not drawn or pointed.
That's what I'm trying to figure out. You're indicating that the weapon would have to be drawn to have a felonious assault. When, if there were no weapon, but he threatened the officer and the officer had reason to believe that he could do that. And that would clearly, wouldn't you agree, be an assault?
I think there's an indication in this particular instance that he was in a position to do that, Your Honor. In this particular instance, the officer has control of everything that's going on. I think this is more of a situation of my client is in fear of what's happening and is rambling words and just spewing things.
Oh, no. He's not rambling. He is directing words at the sergeant in hopes of having a certain result. That's what he's doing. This isn't just some wild rambling. Go ahead with your argument. I'm sorry, I didn't mean to.
I know, I let it rest, Your Honor.
In this case, with regard to the fleeing and eluding third degree, defense's argument of the timeline, I think what one needs to really pay attention to in the body cam footage is to figure it out. Because if you just say 20 seconds or 50 seconds, maybe that doesn't seem like a long time, depending on the speed at which you're traveling. If you just watch the vehicles or the houses that go past in the back of the video, you can see that Mr. Styron traveled quite a ways, and certainly could have pulled over within that time frame. It isn't like he just went 2 houses down. He is behind him for a long time, and Mr. Styron doesn't pull over. I think certainly that gives the court basis to find over on count 1. With regard to the police officer resisting and obstructing, I think the body cam is probably the greatest indication that he resisted and obstructed the officer. The officer told him, he continued to verbally fight with the officer regarding that, and so the people have sustained their burden. Count 3, the driving while license suspended, follows along as misdemeanor. Regarding the felonious assault, court does believe that a felonious assault occurred, which quite frankly is, in my estimation, why the sergeant had his weapon drawn. That at the time that
And when someone with a concealed pistol license tells an officer with a drawn weapon that they're armed, while refusing to comply, and while saying things like, "I'm going to cook you," yeah. The judge calls that felonious assault. The judge basically summarizes the whole event like a frustrated parent. Styron didn't pull over when he should have. He escalated by arguing. He refused lawful commands. He admitted he had a gun. He made what she considers a credible threat. Her exact vibe: this officer showed more restraint than I ever could have. What gets me is Styron's tone in the video. This isn't the scared, trembling, "Oh my God, please don't shoot me" energy the defense tries to sell.
he is giving commands to Mr. Styron. Mr. Styron is refusing to obey those commands, then informs the officer, and I would say not in the way I don't think that's contemplated by our laws regarding having a concealed weapon or CPL, but informs the officer that he is armed, then makes statements that at some point may have been clarified, but about cooking him and other things. All of those taken into account, this court believes, constitute an assault because he is, in essence, reasonably making a threat. He has the ability to carry out that threat. The fact that that threat involves the use of a weapon, this court believes with that analysis, there are other facts and circumstances that play in when you look at the body cam footage. The court believes that in and of itself could constitute a felonious assault in this case, and will bind the defendant over on the requested added count 4. That then, as to count 4, the court having found that, as to count 5, the felony firearm, the people have sustained their burden of that, as there is the firearm present and also have sustained their burden as to count 6 of felony firearm. So the court would bind the defendant over to stand trial on counts 1, 2, 4, 5, 6 with 3 following.
Your Honor, for the record, count 4 is felonious assault.
Correct.
At 0.81.
Give me that again, I'm sorry.
750.82.
Correct.
A 4-year felony and or $2,000.
Right.
Count 5 and 6 are 750.227B.
7D.
B is in boy.
Okay.
Mandatory 2 years in prison, consecutive and preceding any other sentences.
Right.
Thank you, Your Honor.
Mr. Keller, do you waive presentation of the information?
Yes, Your Honor, we would.
And waive its reading. And
Yes, Your Honor, we would waive the reading. We would stand.
defendant having waived formal reading standing mute, the court will enter a not guilty plea as to all 6 charges. Pre-trial in this matter will be set for
November 18th at 1:30 before Judge Slay Monday.
November 18, 2024, 1:30, Slay Monday. Bond will continue. Thank you.
Thank you, Your Honor.
This is You're on My Property, bro, and I'm not going in cuffs today energy if he was terrified. He hid it under 3 layers of attitude, bravado, and questionable decision-making, and in the end, the judge binds Styron over on almost every charge, including resisting and obstructing. He pleads not guilty, and the case moves forward to trial, so yeah. I'm going to cook you turned into years of potential prison time. If you were the judge, would you call those words a real threat, or was this officer too quick to escalate with a gun already drawn? Let me know in the comments, because this one is divisive. Thanks for watching. Folks, if you want more real courtroom drama broken down just like this, hit that subscribe button and turn on notifications.